Well, good morning, everybody. Thank you for coming to our coffee chat with Eldon. My name is Harrison Furlow. I'm Iowa Pork's new public policy director. If you haven't met me yet, I joined the team at the Iowa State Fair, and so they threw me into the fire right away, and it hasn't stopped since. But good to be with you. As you all know, the man next to me needs no introduction, Mr. Eldon McAfee with Gentry, Iowa Pork's counsel. And we're grateful to have him here today to talk about a litany of ag issues which affect pork producers here in the state of Iowa and beyond. And so I'm going to pass the mic to him and let him get us kicked off, and appreciate you being here. So thank you.
Good morning. How's the sound? All right. And you want me to tap on it a few times? Okay. All right. As Harrison said, good morning. We've got a lot of things to go through today, 80 slides there, and we're going to cover each and every line of those. And as I often say, there will be a quiz afterwards. But first of all, if you didn't get an outline, we'll raise your hand or something, and we'll have somebody bring one to you. We have plenty back there. Harrison's going to help you out there. So it's an outline, a copy of all the slides that we're going to cover today. Will we cover each one of them? Well, they gave us an extra half hour this year, so I probably shouldn't say this on our recording, but as long as my bladder holds out, we'll be fine, all right? So, boy, I'm going to live that one down for saying that, aren't I? Anyway, never mind. All right, taking a look at the slides here. First of all, let's start with the how many, I'm just curious, how many presentations do you go to, and humor me here, that have a table of contents for their slides? All right. It's just me, Paul, right? All right. I feel honored. I was telling Harrison I probably violate every rule in the book when it comes to PowerPoint slides. What is the rule? You have only so many words per line, and I just blow that right out the door because I cram as much as I can into these slides. My goal is to give you something that is hopefully a resource. I like to give you rule numbers and that sort of thing. At the same time, get the general topics across to you. So yeah, on some of these you're probably saying, Eldon, need to have my prescription for my glasses checked, as I do too, because it gets a little small when I cram it in there. But hopefully you can enlarge it, etc. Again, my goal is to give you something that you can use and look at later and not have to try to remember what I said. That's why I try and include as much information as I can in each slide. And also I found in going back through these slides, getting ready for these talks, I look at previous years and I think, okay, did I cover that topic? Well, hence the contents. That's why one reason I put the contents slide in there, so I remember what's in there and also what slide to go to. I hope it's helpful. I find it helpful, so that's why it's there. I'm not going to cover a whole lot or tell you what we're going to talk about. I think we'll get right into it. I'm not sure we'll use the full hour and a half here, but often I say that and then boom, I'm cramming things in at the end of the talk. I decided this year to start with what I would like to call good news. Sometimes I think it's not unusual for in general, but we as producers, we as an occupation, we as an industry, you come to this talk to hear about, okay, what's happened, what's going wrong, who's suing us, what new rule did get adopted so that we have to do something different, and we'll talk about some of that. But I wanted to start out with some good news, and that's the first slide, nuisance lawsuits. Now, I don't want to jinx us. I don't want to be, tooting our horn here and then have it come back to bite us. But in looking back through some previous year slides and presentations, like in the early 2000s, this discussion on nuisance lawsuits took up probably 3/4 of the time because we had a lot of them to talk about. Fortunately for livestock producers in the state of Iowa, and again, I hope I'm not jinxing us, right now I am not aware of any nuisance lawsuits. What's a nuisance lawsuit? Most of you know it's when the neighbor files a lawsuit in court and says in that lawsuit the odor is terrible, flies, etc. I can't stand it. It's a nuisance, and I want you to stop it, and I want you to pay me money because of what you've done to me. Right now, as I just said, I'm not aware of one of those lawsuits on file in the state of Iowa against a livestock operation. That's a good thing, but it's also a thing we need to continue to do a good job. And I think one year, several times I've been quoted in this presentation as saying the best nuisance lawsuit to prepare for as a producer is the one that never gets filed. Okay? Plan your operations, and I know you do, but keep doing it. Don't let it down thinking, okay, maybe they've given up on us. Maybe I'm okay. I hope we are, but don't let your guard down, I guess is the best way to say it. A little history there on slide 3. From 1994 to 2004, we had 7 trials in the state of Iowa, and they pretty much all went against us. Okay? Then we take a few years where they were filing lawsuits but didn't go to trial until 2008, and between 2008 and 2019, again, we had 7 trials. 4 swine, 3 cattle, and luckily, and I don't know that luck has a whole lot to do with it. I believe that we as an industry have worked hard on this. 6 of them went our way. A complete flip, from the first, 10 years there. 3 verdicts finding no nuisance for swine. 1 did find a nuisance, and the neighbors were awarded money. 3 cattle operations and no verdicts finding a nuisance there. And here's the key to me. The last 3 trials, 2016 and 2 in 2019. So how many years ago has that been? We're coming up on 7 years. Those last 3 trials, there were no verdicts against the livestock operations. And I believe, as much as anything, that has sent a message that when you take the facts, not what you read in the paper, not what somebody is quoted in the paper as saying how terrible it is. When you put the facts in front of a jury, and these are not 1 or 2 day trials, these are usually week-long. A couple of them were 2 to 3 weeks long. Some, and put all those facts in front of a jury, and these are operations that the neighbors were convinced were a nuisance, and other witnesses and people who live in the community, neighbors, people who work in the community were willing to come in my opinion anyway, tell the truth and say, yeah, there's odor there, but I never pay attention. It's living in Iowa. It's not a bother to me. Juries hear that evidence, and they found it was not a nuisance. I think this is huge, and I think it's something that we all should be proud of, but we should also work hard to make sure that doesn't change, okay? All right, slide 4. I'd like to think most of the reason we're not seeing the nuisance lawsuits is because of the job you as producers are doing, and what the evidence has been presented to those juries shows that, and what other people think of your operations. Pardon me. Boy, I'm 5 minutes in and losing my voice. Harrison, you're going to have to pick it up here in a minute. All right. And those of you who follow a nuisance defense law of right to farm law, there's a long history here in the state of Iowa, starting in 1998 when the Iowa Supreme Court found the nuisance defense law, which we've had various versions of it, but basically it says if you do things right, like I've just talked about, you're not a nuisance and you shouldn't even have to go to court. Well, the Iowa Supreme Court in 1998 96 and again in 98 found that law, various versions of it, unconstitutional. Okay? So, anyway, that had a very negative effect on the livestock production in Iowa, and we saw a lot of nuisance lawsuits filed late 90s, early 2000s, and then what this slide tells us, it took until June 30th of 2022 for the Iowa Supreme Court revisited that law and ruled, and it was a 4-3 decision, so it was close, but the Iowa Supreme Court overruled their earlier decisions and found that law is constitutional. Now, we haven't had any court cases then to challenge or to address the effect of having that nuisance defense, but as I state in this slide, Iowa livestock producers, bullet point, the second yellow bullet point there, Iowa livestock producers once again are protected from nuisance lawsuits as enacted by the Iowa legislature. To qualify, producers must continue to use good management practices, the same practices that Iowa juries have found to be effective. Any question about where we sit with nuisance lawsuits? Okay? All right. Here's a slide. Sometimes I gloss right over this, but it's slide number 5, steps to help avoid a lawsuit and also qualify for the nuisance defenses. Location, location, location. That's probably just can't be stressed enough. The tree buffers, a lot of you, you and your clients and customers are using buffers, fast-growing trees along with slower-growing trees. I went by a site the other day. I worked on a nuisance lawsuit in the late 90s, and those trees now are 30 foot tall, and you can, when the leaves are on in the summer, you can barely see the buildings. It has to have a positive effect on any odor from those buildings. Building ventilation management, management of manure storage structure, keep the buildings clean, do a good job with mortality handling, and then overall, what I call overall operational environmental management, including neighbor awareness, communication, and relations. Pay attention to your neighbors, treat them as good neighbors, and many times they will return that. Okay, switching gears now, we're on slide 6 to what I've termed animal welfare laws. Totally different subject from nuisance lawsuit, but I also fits under the heading of good news. You have heard these laws referred to as GAG laws. I refuse to use that term. It's a term that has been coined, I'll use that term, by some of our opponents to livestock production, and it's by its very phrase that they want to use, they believe we are muzzling people and not letting them talk about what's going on in our livestock operations. I use the term ag fraud or ag trespass laws because what these laws are really about, and we have 7 of these, and that's what confuses a lot of people from a national perspective. I had them say, well, they couldn't get it right, so they amended it. No, what the Iowa legislature did is when a court, and we've had a lot of court rulings against us, when the rulings would go against us, the legislature would come back. I mean, we started on this in 2012, okay, and the last law that we'll talk about was just amended last year, but the major ones were in 2021. So the Iowa legislature was continually trying to give you something as producers that make it a crime for somebody to violate your property rights. Okay, that's what to me what it's all about is, yes, there's a right to free speech, but that right to free speech, and the courts have pretty much ruled, ends when the person who wants to exercise that right breaks the law and trespasses onto your property or uses false pretenses to get a job working in your operation. That ends then. And that's where these laws, the court has balanced property rights, right to free speech, and the way these laws are narrowly tailored, there's a term the courts use, not to be too broad, the courts have found they are constitutional. Iowa is the only state in the country that I know of that has had these laws found to be constitutional, this many of them. Idaho had good luck. We patterned our law, several of our laws after Idaho. And Texas has had some good luck. We'll talk about the drone law. But here again, I think Iowa should be proud of what we have come up with to protect producers from those who want to harm us. Well, let's talk some details here. The 2012 Ag Fraud Law, false pretenses to obtain access, and false statement on a job application to be employed. The court ultimately, and even on the appeals level, the right to limit access was found to be constitutional, but the employment part was found to be unconstitutional because it was too broad. Hold on, the legislature then came back in 2019 and passed a law that was designed to address the court's concerns. So what happens then? In 2024, the Eighth Circuit looked at it again and says, well, you got it right this time. Both parts are constitutional. So we now have protection for livestock producers that makes it a crime both to deny access to trespassers, etc., and then to make it a crime to make a false statement on a job application. Okay? Well, along in there, another law was passed called the Food Operation Trespass Law that applies to more than just livestock operations. That law has been found constitutional by an Iowa district court. Then we go to, here's several laws that were passed in 2021. The Livestock Transportation Protection. That law has not been challenged in court, but if someone knowingly interferes with a motor vehicle transporting an agricultural animal, they have committed an offense. First offense, aggravated misdemeanor, and subsequent is a Class D felony. Unauthorized sampling. Neither of these laws have been tested, as I said, in court, and I'm not aware of where they've even had to be, quote-unquote, threatened to be used. Here's the one that has received a lot of attention since it was passed in 2021. It was challenged almost immediately as being unconstitutional, is a person committing a trespass. So you take a trespasser who uses a device, camera, whatever, to transmit or record images while the device is on the trespass property. Again, first offense, aggravated misdemeanor, then subsequent Class D felony. As I said, this law was challenged almost immediately, and then when it got to the Eighth Circuit, it was found unconstitutional by our federal district court. When it got up on appeal, January 8th, 2024, a little over 2 years ago, the Eighth Circuit said this law is constitutional because trespassers, first of all, they committed a crime. They trespassed onto the property. Then they took a video. The court said trespassers exasperate that harm when they use a camera while committing their crime. The act is narrowly tailored to target that harm and redress that evil. Okay, well, following that, two organizations, PETA and the Iowa Citizens for Community Improvement, then just challenged the law and challenged it was ruled to be constitutional on what we call a facial challenge. There were no facts involved. Both of these organizations then said, let me give you the facts of why we think the law is unconstitutional, and they laid out some of the things they do at livestock operations. Beyond that, sit-ins at congressional offices, protesting at businesses, etc., and they felt the law was unconstitutional. The district court followed the Eighth Circuit's ruling, as we have on slide 15, saying that, again, the quote I just used, but the court also noted that, okay, a trespass is pretty much, it happened kind of one moment in time. They're there, they leave, or they're arrested and leave. When you record that and save that recording and put it on the internet, etc., that changes something that was momentary in time to a permanent invasion or a perpetual invasion, as I have here in the slide, and that makes it a lot worse in the court's mind. And the district court ruled against them and ruled that it was constitutional, but this is the last one on appeal, and the oral arguments were just a week ago. We're expecting a decision from the Eighth Circuit at any time, whether as that law applied to the actions of Iowa Citizens for Community Improvement, as stated to the court, the Eighth Circuit will rule whether that law is constitutional, specifically in that context. Okay? All right. How many of you are aware, I mentioned it already, of the drone law we have in Iowa? Okay? That makes it a crime for certain uses of drones. How many of you use drones? Just, okay. you won't get arrested for using it if you use it on your property. How's that? Let me make that clear. This law first started in Texas, was the first one to adopt it that I'm aware of, and they promptly got challenged and found unconstitutional, took it to their appeals court. That appeals court found it constitutional, and then the opponents tried to appeal to the United States Supreme Court, and the United States Supreme Court rejected it and did not take that appeal. Iowa's law is patterned very closely after the Texas law. Ours has not been challenged in court, but I wanted to go into a little detail here in case you're interested. What does the drone law do? It prohibits drones, remotely piloted aircraft, from flying within 400 feet of, this was when it was first adopted, of homesteads or livestock facilities. Violators face criminal penalties included for intruding the airspace, and the penalties are, I won't go, misdemeanor, aggravated misdemeanor, etc. But there's also a potential 2-year injunction against whoever is using that drone from getting near you if harassment is proven. Okay? And the court can order and shall order destruction of any image or sound or data that was obtained by that drone operator. Now, there are exceptions, and one, I believe that I'm smiling a little bit here because the focus of a lot of this talk today is supposed to be about DNR. The question is, can DNR use drones? I'm not aware of them doing that, but there's an exception to this law for authorized governmental use. Okay? I assume that would apply to actions of the Department of Natural Resources. If you'll notice, one of the penalties for the drone law and unauthorized use is not to get the 12 gauge out and shoot it down. Okay, that's not one of the penalties. I better leave it at that, hadn't I? I often hear, who needs a law? I'll take care of that thing. Okay, 2025, the law was amended to make it went beyond livestock facilities. Now we're talking about crop equipment, machinery and equipment. So that's included as a farmstead, which is defined as property owned or leased by the farmer, including a crop field or pasture. And again, that 400 distance applies. And used by the farmer to produce animals, etc. So that's where our drone law sits today. And I'm not aware of it having to be used, but I think all of us should be aware of it. If someone is using a drone around your property, now you might say, how do I find out who it is, or how can the law be enforced if we don't know who it is? I'll leave that up to you. All right. No, I think you have to gather that information, get a hold of your county attorney, and let them know what's going on with this drone. Obviously, some video. And I don't know. I don't have a drone, never flown one. Do they have numbers on them somewhere? Do you have to register them? Anyway, now keep in mind that why that 400-foot distance? Because above 400 feet is when the federal regulations kick in, and federal law regulates drone use. But I don't hear much about it, which maybe is good, but I want all of you to know I think we have a very good law to protect us from the unauthorized use of drones. How about a summary of these laws I just talked about? I said there are 7 of them, and there are. I've pretty much covered a lot of this. 2012, that law has been upheld in part and dismissed in part. 2019, we got protection for both unauthorized access and employment. 2020, the food operation trespass law that goes beyond livestock facilities. The electronic surveillance law, I've just explained it in detail, and I believe we're in good shape with it as far as its constitutionality. The livestock transportation, unauthorized sampling have not been challenged, but they're there. It's primarily the livestock transportation law is to protect against interference with transportation of animals, and then, of course, the drone law. Any questions about those laws? Okay. How about some practical steps so we don't have to worry about lawyers and law enforcement and crimes and all that? And a lot of you know this, and a lot of you are doing a great job with it. Maintain physical security, such as locks on doors and entrance gates. Electronic security is video surveillance. And video surveillance hopefully will help deter it, along with give you good proof in case you do have to invoke one of these laws. No trespassing signs. I've worked with several producers on what to state on a no trespassing sign that refers to these laws. In the employment context, as I say, easier said than done, but conduct extensive and detailed review of job applicants and adopt welfare policies and train employees in proper animal husbandry, and then instruct and encourage employees to report anyone who is not following proper animal husbandry. You need to work with, I think if you probably have ideas beyond this, I'd be interested if I need to add anything to my slide, but hopefully we can use these things to avoid these laws, but if have to use these laws, but if we need them, they are there. Okay, now we're on slide 20, and well, half hour into it. I want to be getting to DNR here in a little bit, but we've got some things to cover. We'll get there. Okay, Prop 12 and Massachusetts Question 3. I have a slide here on the U.S. Supreme Court decision from 2023 that found this law adopted by California. I'm not going to go into any details. I think everybody here knows what it does. That law was, in fact, constitutional, did not violate the Dormant Commerce Clause. It was a 5-4 decision, one of the most controversial U.S. Supreme Court decisions, you know, when you get out of the areas of maybe some of the personal rights and some, but when you get to the business side of things, maybe is the way I'll term it, this is one of the most controversial decisions I've seen. Everybody that reads it, lawyers, says, oh, it means this, it doesn't mean this. It's been called a very fractured decision, obviously at 5-4. Anyway, it is the decision. It's from the U.S. Supreme Court. But we still have some court cases challenging Prop 12 in Massachusetts Question 3, even following that U.S. Supreme Court decision. The Iowa pork producers participated in one as a plaintiff, and it was ruled against and found to be constitutional. And ultimately, the U.S. Supreme Court on June 30th of this past year refused to take the case on appeal with a very unusual note, actually. It was just a line item noting that they were not going to take the case, with the note that Justice Kavanaugh would grant the petition and would have allowed the case to go to the Supreme Court. He's the judge who wrote a lot of the dissent in the MPPC decision, so probably wasn't a surprise. He wants to hear the case again. So what's pending out there now? In July 9th of this year, the United States government, Department of Justice, filed a case in California alleging that Prop 12 has increased egg prices, and that Congress has preempted Prop 12 through the Egg Products Inspection Act. That case is percolating through the courts right now. There has been no decision yet, either at the district court level. And then Triumph Foods filed a case on September 25th of 2025 alleging various constitutional claims that were basically some that the U.S. Supreme Court dissent had said, here's some other avenues, including alleging discriminatory conduct. That case is also, quote-unquote, percolating in the California District Court. Now we have Massachusetts Question 3 as well, which is very similar to Prop 12, and two lawsuits there. One that MPPC, this Massachusetts Restaurant Association, MPPC, participated in that as one of the other plaintiffs. And mainly right now, Massachusetts Question 3 applies to pork, what we call transshipments, pork moving through Massachusetts, whereas California looks at the end user. However, Massachusetts is not enforcing the transshipment part now until they get rules done, and those rules can be examined, I guess is the word to use, as part of this lawsuit. So it's quote-unquote on hold. But both of these laws, California Proposition 12 and Massachusetts Question 3, are in effect and are being enforced. And then Triumph Foods also filed a suit against Massachusetts Question 3, and that has worked its way through the district court and the Court of Appeals, and both courts rejected their challenges, and I believe the period is still open as to whether they will apply to the U.S. Supreme Court to review that case. That's where we stand, okay? All right. Now we're done with animal welfare laws, sort of. I think, let's see, we're on slide 22. Just checking through my notes here if it says don't forget to say this, and I don't see that here. I included this slide because IPPA had a question from some producers this summer who had been to a national conference about feral swine and what a serious problem it is in a lot of states. We're talking, the wild razorback types mainly, but it is a real problem in some of the southern states. And what the question was, well, what has Iowa done? And I think most everybody here will agree we don't have a problem. Right, Harrison? Okay. Here's what Iowa's done in the past to address this. And you don't hear a lot about this, but there's really three laws. There's one that was adopted in 2000 about livestock and hunting preserves, and that prohibits hunting livestock on hunting preserves. Those are the private businesses that allow hunting on private land. Then we have the law that was adopted in 2007 for dangerous wild animals. And this was a law that was pointed at people who keep lions, tigers, whatever, and regulates how they can keep those animals. Well, it was amended to add what I would call the razorback type, these Russian boar, European boar, either sex, but what we all think of as feral swine, and I call them the razorbacks, no offense, Arkansas fans, but that law prohibits owning or possessing dangerous wild animals, which include these types of swine. There's been some issues with that law, both of these laws. I think some of you can probably say, I know of a hunting preserve that has these, and the Department of Agriculture has had to work with some of those hunting preserves to get into compliance with the law. Well, in 2020, a law was passed that it really wasn't brought with the concern of what we would call traditional feral swine. The concern was sometimes we have just swine that get loose, hogs that get loose, get off of a trailer or whatever. And with the biosecurity concerns we have in the industry today, even if another producer or somebody saw those, they didn't want to touch them. They didn't want their employees to have anything to do with them. We were just hearing concerns about loose hogs. And so working with the Department of Iowa Department of Ag, this law was adopted, and feral swine is defined as any swine running at large. Doesn't have to look like the Russian boar. It doesn't have to be on a hunting preserve. If there are loose hogs around, that violates this law. The Iowa Department of Ag may destroy those found on public or private property, but only after making a reasonable inquiry to determine ownership. Department of Ag didn't want to be, quote-unquote, destroying somebody's pet pig or something, okay? Individuals, and that's this last bullet point here, any person may destroy feral swine found on their property or damaging their personal property. So we're not talking about public property or out in the road, which IDALS has authority over, but if they're on your property, you don't have to make a reasonable inquiry to ownership. You may destroy those hogs. And you're not required to conduct a reasonable inquiry into ownership, then you must notify IDALS so they can test the dead swine, I guess it is. And no person may knowingly release swine to be, if there are people who are releasing them on purpose. That violates this law. Any questions about the feral swine law? Okay? That last one is about as strong about as strong a law as you can get. If that pig's loose and it's on your property, it's like that drone I mentioned, I guess. And I smile about it, but it is a serious issue. Loose, I'll call it loose or stray hogs, are a serious biosecurity threat, and that's why this law was adopted, to allow IDALs to do it on any property. The property owner, to protect their property, can do it as well. Okay? All right. Now I want to talk, I'm still on the top, at the end of all this discussion here on manure easements and agreements, there's several court cases I want to talk about. Then we'll get into the specific DNR issues that I want to talk about as far as dealing with the Department of Natural Resources and how they're interpreting some laws and how I think they ought to be interpreted, and some effective dates. So we're on slide 23. And this goes clear over to, over to slide 30. I don't know that I'll go through a lot of the details here on in a manure easement agreement. I have that term used interchangeably there. But it's a manure agreement if you have the livestock operation, hogs, cattle, whatever it is, and you don't have enough of your own land to put it on, then you enter into an agreement with somebody else to put it on their land. Now, DNR requires that, I have the rule requirements here on slide 23. There is a DNR rule requirement that if you are putting manure on land that is owned or rented for crop production, you don't need one. But if you put it on any other land, so if you're farming land, DNR doesn't require you to have a manure agreement there, okay, even though you don't own it. If you rent it for crop production, you don't need one as far as DNR is concerned. I might suggest you have one, but I'll leave that up to you. That's what DNR requires. That manure agreement is usually pretty short and just covers the DNR requirements. But for most producers, if you have a lender involved, a lender usually wants to know if I'm going to lend you money to put up that building, I want to make sure you have a place to go with the manure. And that's when we see a lot of these agreements, and producers want them as well. Usually they're much longer than the 1 year. And they can go anywhere from couple 3, 7, 7 to 10, the life of the loan, and we see some agreements, which we'll talk about in some of these court cases, is an issue that will go for the life of the building. And some of those buildings are going to be there a long time. So they can be for, I've seen one that was specifically written to be 99 years long. We're seeing some very long-term agreements, which protects, I think, both the landowner from getting that manure, but the building owner for having a place to go with it as long as they're in operation. Unless you have any detailed questions about some of these terms, I'm probably going to move through it. Slide 25, I asked some questions. Who is responsible for the application? Who pays for it? Is there any charge for the manure? And does it state specifically where the manure should be applied? Are there restrictions on when it can be applied, and yield records, etc.? Okay, this is one of those areas where I, as an attorney, I do work with manure agreements. A lot of attorneys do handle these. And some, I've never had a client walk in my office or call me on the phone and say, write me a real long one, real detailed, Everybody wants it short and save the legalese. And don't put your kids through college on this one. Just cut back on the numbers or on the number of words, etc. I'm fine with that. But we'll talk about a few court cases here where it would have sure been nice if the agreement was a little longer. I'm just saying short is good, but you've got to have some detail in there or it can run into trouble, okay? Other nutrient applications, the agreement should state what comes first, the manure or the other nutrient applications. The agreement should probably state that you're not, as a livestock producer, you're not warranting the value of the manure or the quality. And then a real key, does it require that a certain minimum amount will be applied. And here's slide 27. You might want to circle this because this is where some of the lawsuits come from. Landowners may want to be assured of receiving a minimum amount of manure each year or over a period of time, and the producer may not want to be required to provide the manure. They just want the right to apply it. A true easement, if you use that legal term for real estate, just gives somebody the right to do something on somebody else's land. Doesn't require them to do it, like an access easement to get to somebody else's land. It gives you the right, but not the requirement. A manure agreement for that landowner who wants the manure should state that, yes, you have the right, but you also have to put it on my land. It can't go anywhere else. And that's where the agreement needs to be clear about that. And I just covered that there on slide 28. Also, the second bullet point there, for the agreement to run with the land in case the land is sold or the livestock operation is sold, it should be recorded with the county recorder. And then a non-disturbance agreement if there's a lender involved. Slide 29, you may want to require a corn-soy rotation if you're the owner of the livestock operation, so that you're assured that the crop is not put in that doesn't require much manure. And the landowner may require the producer to not implement any practices that reduce fertilizer value of the manure. We see some agreements that are concerned about the amount of water that may be added to the manure, either intentionally or inadvertently, etc. And then, of course, every lawyer's favorite subject, liability, and every insurance company's, they want some coverage or some statement there about who's liable for what. Okay, we're now on slide 30, and we'll talk about a few lawsuits. When I first started dealing with manure, when I walked out of the dairy barn in 1988, went to law school, and then became an attorney, manure agreements were first coming around, and I remember working on as one of the attorneys for the Iowa Pork Producers Association, looking at various agreements and how they could be written. Mainly, we were concerned then about, quote unquote, getting rid of it, have a place to go with it. You would think, and this leads me into the lawsuits, you would think the lawsuits would be mainly about, I don't want it, or I don't want to have to take it. Most of these lawsuits, with the exception of the last couple I'm going to talk about, are about, hey, I thought I was going to get it, you're giving it to somebody else, I want it, and they're willing to go to court to get it. I give a talk to attorneys every year in December. We attorneys have to have 15 hours of continuing education credit every year. You know, and I know you're so shocked, but attorneys wait until December to get that in. At least it's the first part of December, not right before New Year's Day, okay? I give, and it's, surprise, surprise, it's a seminar Drake Law School puts on for attorneys, and it gives you the 15 hours you need, exactly. Well, one of the topics, and they've had me do this for 20-some years, is to talk about ag law. And I will say this, back in the days when we did them in person, I usually saw the back of the Des Moines Register most of the time during my talk, okay? A lot of these are not agriculture attorneys, so they're not real interested. But some are. They'll get like 300 sign. That's how many attorneys put it off till the last month of the year, I guess. But the reason I'm telling you this is when I give the talk about manure agreements, because quite a few attorneys represent landowners in rural Iowa, et cetera, and I talk about it because their clients may be asked to sign one of these. But I talk about the lawsuits, as I just said, are usually about who didn't get the manure and not about who had to take it. And that I can even see the surprise, and sometimes I get questions about that. That, to me, in addition to being about a manure agreement, shows those attorneys anyway how much of a resource manure is. Because the public doesn't always hear that, do they? That how that manure is a very valuable resource. It replaces commercial fertilizer. They just hear how bad it is and what it's doing to our waterways, right? Or what they think it's doing to our waterways. So I don't know. I guess I'll get off my soapbox now, but I think it's something that that people need to understand how important these agreements are and how important it is to make sure if that landowner wants it, that agreement specifically requires that the livestock operator provide that manure to them. This was a case like that. And most of the problems happen not between the original two parties, but if the livestock operation sells, then, and that's where a lot of these cases come from, that new owner looks at it and thinks, you know, I could really use that manure myself. Are these agreements really binding once it sells to me? And that's what this case was about. I won't go into the details of that case. Same here, this case from 2016 on slide 31. Again, the point is, people cared enough about getting the manure, they would pay a lawyer to go to court and fight to try and get it. And this lawsuit as well, this lawsuit in 2017, the building sold and the new owner converted a sow unit to finishing, and the court ruled that the easement applied to both parties. The agreement was not specific as to the type of the manure, and the crop farmer was not limited to half of manure for corn. I mean, there are some details there. The value was based on a commercial fertilizer rate. This was an agreement that was fairly detailed, but there were some details that had to go to court to find out exactly what it said. All right, another case there on slide 33 from 2024, where the agreement set out 65% of the commercial fertilizer rate. Well, exactly what did that term mean? The dispute was whether the price was 65% of the price charged to the landowner or 65% of the general price. The landowner claimed, hey, I get a better deal, so that 65% is lower than what it would be for anybody else, and the court ruled that the price was the dealer's standard commercial fertilizer rate. All right, here's a case that was just decided in 2025, and the term of the agreement was 20 years, okay? And it said 20 years, and then what all of us would call an evergreen clause, all right? And after, as long as the hog farm is in operation, and you won't hear me say this much about a slide, but comma, notice the comma after operation, or until 18 months prior written termination notice by either party. This was a case where the landowner had sold the farm and the new owner did not want the manure agreement, wanted out of it. So the landowner went to court and the fighting issue was, remember when I said comma after termination? The question was that until 18 months prior written notice, did that apply only during the evergreen, what I call the evergreen clause, or during the first 20 years? And and I'm chuckling. This is a court decision you can read. And in all fairness, I was involved in this case. My partners were. And the court ruled that there's a doctrine of statutory construction called the last preceding antecedent. And if there was no comma there, the 18 months prior written notice would have only applied for the after the 20-year term. But because there's a comma there, the court ruled, and there's precedent to back it up, that it applied to everything in front of the comma, okay, which was the first 20 years. And that was the key, that we were still within the 20-year period. The landowner gave 18 months written notice and wanted out. The hog operation owner said, no, you only get that 18 months written notice option after the 20 years. And it literally, okay, I don't like to give you a lot of war stories, and I certainly don't want to tell you about any cases I lost. But anyway, and there have been quite a few, okay. I stood in front of the Court of Appeals and I said, there had been cases in front of us. They take like 3 cases for the morning, and there were people in the audience or the gallery or whatever. Ours was the last case, and everybody left. It was just us. And I stood in front of the court and I said, where's everybody? This is a case about manure and a comma. What's more exciting than that? And the judges did chuckle a little bit, but it boiled down to a comma. So, why am I telling you about all this? Okay, do you want me to give you the lawyer saying pay me now or pay me later speech? Okay, Sometimes we get these agreements and you think, okay, it worked for them. That looks good. Just get me an agreement. And we cut corners. We make them short. This is a case to tell you, please pay attention to, again, this provision. And I've probably got some out there. Believe me, I haven't went looking through my files to see if I've got commas in the right place. But it just tells you those details can be very important. And hopefully, if you can pay attention and you and your legal counsel can, you can avoid this. But when it comes down to a comma, that just tells us again, those words on paper mean something when the two parties can't agree. Okay? Any questions? All right, now we're into DNR rules. And what did I there we go. Well, I'm about, we'll still get her done. Okay, DNR rules. I'm on, I'm going to flip ahead here, make sure of my notes. We're on slide 34, and I'm starting out with, I'm not going to get to, in a little bit, we'll get to all the effective dates, but I just have some general slides here. And this one is biosecurity requirements. I have been told anecdotally that maybe some of the DNR folks, and I shouldn't paint with such a broad brush because in my experience, the DNR inspectors are very, very good about respecting biosecurity. Now, Iowa is one of those states that does not have a standard, from the DNR doesn't have a biosecurity policy. This law, there's two of them there, and this is from the Iowa Code. Slide 34 says that the DNR shall comply with standard biosecurity requirements customarily required by the operation that are necessary in order to control the spread of disease among an animal population. DNR is required, and anybody, other state agency or any, is required to follow your standard biosecurity policy. You get to establish that, and they are required to follow it. Now, your standard biosecurity policy cannot say DNR is not allowed on the property. That one won't work, okay? But just to make sure, we all know how important biosecurity is, have that ready. When DNR comes, have it in writing, and you can say, this is my standard biosecurity policy, and probably before they come, when they call to say they're going to do an inspection, and I know there are consultants in here that deal with this regularly, and I won't call anybody out, but when DNR calls to say, or emails, we're going to do an inspection in a week from now, do they ask about the biosecurity policy? They do usually. And do you provide it to them? Or, yeah, okay. That's the key. And it should be, if the producer does not have a standard biosecurity policy, adopt one, have one. And I'll just say this, as important as biosecurity is to all of us right now, if any of you have any trouble with anyone not wanting to follow your biosecurity policy, let us know, right? Because we're not here to, beat up on somebody, or I am, but anyway.
As consultants?
Yes.
Is it out of bounds to, like when you've got multiple different pieces of info you're working with, like how do you, could I come up with a standard policy that our customers use, or does that have to be something that is posted on a, in that business or something like that?
I'm going to repeat your question so those listening to this online will hear it, and I hope your question is, does the producer have to come up with it individually for them? Can you help the producer with it, if I understand you right? And I think certainly if they don't have one, you can certainly help them, but it should be, quote unquote, tailored to their operation. But I think a lot of them are very similar. Now, there is another entity involved here in most operations, and that's the owner of the pigs, right? And often in the contract, the feeding contract, it will say the contract grower, the contract feeder, is to follow the pig owner's biosecurity policy. So if they do, they should have that, and they should provide that to you so you can provide that to DNR. Now, if they don't have one, I would suggest you go ahead and help them with one that you see a lot of and provide that to DNR. Yes, sir. Who's them? DNR? Yeah. Okay. So want to make sure I understand. If you've got your policy and you tell DNR what it is, that everybody else follows. Yes. Yeah. That does it, if I understood your question right. Yeah. And again, my experience with DNR is they are very careful with biosecurity policies. I've heard a couple of statements otherwise, but my experience is, and I've been in meetings with DNR and remember the EPA DNR work plan 15 years ago, 10 years ago, whatever it was, where DNR had to go around to a lot of sites, and DNR people we were talking to working on that work plan said, we will follow your biosecurity policy, and there's really no reason in most cases for DNR to ever go into the buildings, but they do come onto the premises. But yeah, if you have a policy, provide it to DNR, and if they shouldn't question it. If you get a little carried away, they might, but as long as, again, that you shouldn't have to validate it other than here's my standard biosecurity policy. I just want you through this slide to be aware of what the law says. And the term standard biosecurity requirements customarily required by that operation. Okay? Anybody add anything? I'll pick on you, Brian. Anything you do a lot of inspections, right? And I know there are others out here that do. And biosecurity is extremely important in this day and age, always is. I just want to make sure that it's front and center for DNR inspections. Okay. Next slide is on karst. How many in here have to deal with karst? Okay. All right. I was afraid somebody'd raise their hand. Okay. Remember that SAFOs are exempt. Those are small animal feeding operations, less than 500 animal units with formed storage. If it is in karst, these are rules that haven't changed except for the 7-foot to do your soil corings. There was a lot of talk a couple of years ago about they were all going to change. Karst is a very sensitive issue, no pun intended there, for water quality, etc. And I just wanted to lay out these requirements again for you to have in your notes on the requirements for karst. Okay? The ephemeral gullies and the P-index, I'm going to leave that to any consultants with questions. We're still dealing with that. As we know, this slide 36 and this slide 37 parts of the same rule, and they really don't mesh together very well. They're inconsistent. DNR has told me they are coming with a rulemaking to correct that, and it's a result of a court decision saying DNR was not enforcing the rules. I know it's been a problem for some of you. I won't get into details there unless you have any questions. Okay? That's what happens when I look at the clock and think I need to speed up. Okay, major issue here, at least for me and several of you. You have an operation, say, as a sow unit, okay? Then you decide, the owner decides not to be a sow unit and wants to convert to wean to finish, okay? But doesn't have to change, doesn't have to put in another pit, doesn't have to do anything to the manure storage, but of course has to take out the crates if they are there, etc., and then do something, for heat or whatever if it's wean to finish. But here's, and we're dealing with this quite a bit in various areas of production. I've had quite a few calls on this the last year or two. The rule says that you do not need a construction permit, okay? Even if you're over 1,000 animal units, you don't need a construction permit if you're initiating a change, even if no construction or physical alteration to. This is worded the other way, that you do need a permit, but you don't need it if you don't require. Here, let me go to the next slide. I think I say it better here. Look at the second bullet point. This is one of those where I say, in other words, First bullet point, physical construction or alteration to other parts of a confinement building do not qualify to require a permit. It's only alteration, actual alteration to the manure storage. Second bullet point, if no construction, physical alteration to the storage or modification in the manner in which manure is stored, and if no increase in the volume, even if you're increasing animal capacity, you don't need a permit, okay? You don't know how much this has taken over the years to deal with individual situations with the Iowa Department of Natural Resources, because to many, it really makes sense if you're over 1,000 animal units, either below and you increase to more than 1,000, or above and increase from what you have, because some sites with more than 1,000 animal units didn't have to have a permit at the time they were built. But what it comes down to, if you're over 1,000 animal units and you're increasing those animal units, the department generally believes you should get a construction permit. That's what you need. But this rule is designed to prevent that if you're not increasing the volume of manure you're producing. So what are the issues? Does the site currently have a construction permit? At one point, DNR was saying, well, if you're below and go above 1,000, no physical change, okay, that law applies. But if you're already above, it doesn't apply because you already have a construction permit. That's not what the rule says, and we've been able to change that interpretation. But what we've run into recently is, what do you use to determine if you're increasing the volume of manure? Okay, you got to have a baseline, I'll call it, all right? And if you have never had a construction permit, at some point, okay, here's where the next slide comes in. I went back and looked at the various times we've changed who needed to do a manure management plan. At some point, every confinement operation over 500 animal units in Iowa had to get a manure management plan at some point. Look at the 95 legislation said if you had a permit, okay, fine. Then September 22nd, 1995, the DNR rule said even if you had form storage and weren't a SAFO but didn't have to have a permit, then you had 60 days to get your MMP in before manure removal. That was the first time a non-permitted confinement operation had to get an MMP, and it was in the fall of 95. Well, then along come 98 legislation, and it said, okay, that was only for those that after the date of that rule in 95 that built and had to do that. Well, then in the legislation it said, oh no, we want every operation that I just described constructed after May 31st, 85 and up to had to file their MMP by July 1 of 99. And those of you who have been around a while remember doing a lot of MMPs that summer, okay? Then we have another DNR rule. February 13th of 2002, instead of submitting that MMP 60 days before you remove the manure, you had to submit it 30 days before construction. And then the legislation in 2002 required the construction design statements. Why do I bring that up? All right, go back to this slide. DNR, if you're doing a non-construction expansion, DNR needs to know, okay, what do we look at before to know if you're increasing the volume of manure, okay? I was not totally aware of this, maybe some of you were, but DNR tells me they do not keep their files more than 5 years. So if that operation were built, let's just say this slide, back in 96, and you would have had to file an MMP then 60 days before you remove the manure. DNR would say, we don't have that anymore, okay? So what do? They look back at what they have, and that would be the most recent MMPs. And maybe those MMPs, maybe you've already made a change and your manure production is down, but it's not where it was when you were originally built, which is pretty much the capacity. So they have denied, in some cases, your application that you aren't increasing manure production because their records show you are. when you're saying, no, I'm not. Way back here, I was up here. What do you need to do, folks? You need to keep those MMPs in your records, okay? Don't throw them away, because DNR isn't going to help you there. And that's what we were able to do several times, is produce that MMP from way back when, and DNR said, okay, fine, you are decreasing it. So where's my my last bullet point there is keep all MMPs in records as DNR may not after 5 years. Okay, yes? Every year. All right, question was keep them all or just keep the ones that show changes? Okay, I'm sitting here and I can say this, keep them all. Now, if you don't have them all, at least change years would be it. Whatever you have would be very, very helpful, okay? Because we have had some who didn't have way back the first one they filed, but did have one later on that showed manure was up here and able to use that one to show it was a decrease. My advice, and maybe I'm a little bit late to the game here because I'm talking years ago, but keep those old ones, scan them in, do something, because it could be very helpful if you have to prove you're reducing the amount of manure you're producing. Okay? There we go. I wrestled with how to do that slide, and hopefully I got it. All right, we're into in horse racing. We're into the one where we just passed the starting gate. We're going, when the finish line is still down the road. We've been doing this an hour. My voice is holding out, and I still have a lot I want to talk about. So we'll get her done. Slide 41. What about, and this will take a few minutes, so bear with me, a discontinued animal feeding operation. The rules say, and I quote it there, a confinement operation with form storage and more than 1,000 animal units must get a construction permit before repopulating if the operation qualifies as a discontinued AFO for 24 months or more. What's a discontinued AFO? Where if the structures have been abandoned, etc. But look at after the ampersand sign there. Oh, wait a minute, I was too quick. Or after the or use has been discontinued. They took the pigs out, and there are no immediate plans to repopulate. Okay? All right, so what's going on here? For whatever reason, you're done. You're not going to tear it down, but you're going to quit using it for a while. You take all the pigs out. DNR rules also say you get the manure removed within 6 months, etc. But DNR uses the term mothballing, and we'll talk about that in a little bit. I don't like that term because it doesn't really work. Anyway, you take the pigs out, it's empty, and you're thinking, well, I'll sell it, but say the market goes in the tank, which we have some experience with, right, here recently. So buyers aren't real interested, so it sits there. Well, then at some point, you either decide to put pigs back in or sell it and somebody else will put pigs in. If that's more than 24 months, okay, that it's been empty. All right, let's go to this slide. DNR interpretations. A repopulated AFO discontinued for 24 months or more is a new AFO. That's their interpretation. What does that mean, being a new AFO? Repopulated AFO loses, well, first of all, a construction permit is required, which I just talked about. But also, you lose your grandfather status. What grandfather status are we talking about? You know how, and I've got a slide on it, you have different separation distance from neighbor's house based on when you built, and those distances three times have went up. If you had the lesser distance and then you stop using it for 24 months or more with no immediate plans to repopulate, then when you bring it back in, DNR says you got to meet those new separation distances, which maybe you can't. Maybe it was 750 and now it's 1875. Maybe that's a problem. What do I have here? Oh, the exemptions such as the master matrix exemption for being under 1,666 animal units, that's a grandfather status. You lose that. You are considered a new animal feeding operation like you were building it today. Pardon me? Over 500 animal units is what we're talking about, anything other than a SAFO. I took a deep breath there because I vehemently disagree with this interpretation. And DNR knows that. I've had this discussion with them. I realize it's been discontinued and it's been put in limbo. I'll use that term. But the rules use the term discontinued and new in different parts. DNR's position here is it's new, and I'm just telling you about it so there are no surprises. And if you're sitting there thinking, oh gosh, I've got somebody, they had a sow unit, had disease issues, market was bad, they shut it down, they're thinking about starting it again. I don't know, I'm not picking on anybody here, but if that's getting close to 24 months, okay, you're going to have to argue, if you go over that they had immediate plans to repopulate. Example I can give you is a guy that had done this in, I'll throw out a year to protect the innocent. 2018, DNR's response was, that's not immediate plans to repopulate if it's been 8 years since they had pigs in it. So what's my advice to you? To avoid having to be a new animal feeding operation, get a permit, worry about the grandfather clauses. First of all, I'll tell you what DNR tells me you should do. Throw some pigs in there. A few pigs. That's literally what I've been told, okay? Well, I got to be a little careful what I say, but what the heck. Harrison's not going to get rid of me. I said, you got to be kidding me. If I came up with that idea of throwing a few 4-H pigs in a building to claim it hasn't been discontinued, tell to me that was a loophole, that I was, end run around the regulations, etc. But literally what I've been told is get some pigs in there to show that it hasn't been empty. I don't like that idea because, anyway, I'm just telling you what I've been told. What I would do, I'll get your question. What I would do, besides arguing with them like I've been doing, that they are reading the rules wrong, if you're getting close to the 24 months, and I know, don't you like it when somebody says that and you're sitting there thinking, oh crap, I can't remember, what's that date, I got to go look at the file. If it's been after the 24 months, tell you what, I'll offer this and Harrison will back me up. Give us a call. I'll be glad to talk through it. Any of you. I'll be glad to share what I think maybe you can do. And anyway, if you're still within the 24 months and don't like the idea of throwing a few pigs in there, get a hold of DNR. Tell them where you're at. Say, seriously, can I tell you I have immediate plans to repopulate? Can you put it in the file that I'm trying, etc.? I'm very concerned how this is being interpreted and what it could mean for some of these operations out there. Now, maybe, DNR sometimes takes different positions on the same facts. So maybe they won't cause you the issues I've had with some clients. Ma'am, I just avoided your question. Doesn't matter, there were no pigs in there. All right, I'm sorry, I didn't repeat your question. If they have continued to pay the compliance fee, is that immediate plans to repopulate? We've tried that, and maybe it'll work, maybe it won't, but I'll just repeat, I have been told that the surefire way to avoid a problem is have some pigs in there. Okay? All right, next slide, slide 43. The SAFO election, small animal feeding operation election, was adopted, I forget the year, 22, I should know that year. Anyway, what this lady just asked me is about paying compliance fees. If you're empty and don't want to pay compliance fees, you can take a small animal feeding operation election where you are essentially saying, hey, I'm a small animal feeding operation and I don't have to then file updated MMPs or pay an annual compliance fee, okay? You file this election, and I think quite a few have done this. You'll be considered a SAFO only for purposes of submitting the updated MMP and paying the annual compliance fee during the period of the election, must maintain less than 500 animal units, and the law specifically says the election does not affect any construction permit requirements, or any requirement unrelated to filing an updated MMP or paying an annual compliance fee. There is some thought that if you take the SAFO election, that would kind of, I'll use the term, toll this 24 months deal. There's a good legal response for you. DNR's interpretation is it doesn't matter. You have still been empty for more than 24 months. And again, I know this is a serious issue for some people. That's why I'm spending some time on it. And I will tell you that I believe there is a different way to interpret the regulations than DNR is doing. And we're going to take a look at maybe trying to get some help in changing that. But right now I have to tell you the way it is. Okay? Oh boy. Did I get 2 hours, right? Okay. All right. Don't need to look at these slides. Separation distance waiver, slide 46. Had some issues with a rule change in 2016 that says any future expansion can only be included if in the waiver if the waiver includes specific language about it. If you have some of those old waivers, they didn't talk about future expansion. Now you expand. DNR is saying in most cases you got to have a new separation distance waiver. Master masonry changes, you just have to get a new permit. I talked about this last year, slide 48. Okay? I wish there was a different process just for changing the matrix, but there isn't. DNR requires getting a new permit. Manure release reports, I'll leave that to your reading. DNR rules on, see, some of these slides I put in because I was convinced I was going to get to about 10 o'clock and be done. And I thought, well, I got to have something else to talk about here. So these are the fillers, and we don't need them today. All right. Here, I did look at the recording from last year, and I emphasized this last year. These slides, starting on 51, and I want to talk about it again. When DNR comes out to do an inspection, many times DNR will look and say, well, here's current rules, and you don't meet something, okay? But a lot of the rules had, at the time this operation was built, that requirement was not into effect. Groundwater lowering tile, we talked about it last year. Here's the slide of the various dates it was enacted, and here's this handy-dandy little chart. Hard to see there, harder to see in your printout. Let me know if you want a different copy. Last year I told you I was going to work on putting all these together in maybe some sort of handout or whatever. Well, maybe next year. Okay, anyway. Effective dates. The perimeter tile is a big one because, boy, a lot of things changed and different requirements. If there, and I've had questions about DNR saying, hey, you got to have your monitoring port. It has to have a shut-off on these perimeter tiles, or it has to outlet. Take a look at when that operation was built and what was the requirement for that size of operation, because it's changed through the years. Here's another one. Hot topic for some people, human sanitary waste, septic tanks at hog buildings, okay? The rule says human sanitary waste shall not be discharged to a manure storage structure or egg wash water structure. That rule went into effect in Chapter 65 of the DNR rules on May 12, 1999. All right? And human sanitary waste includes derived from domestic uses, including bathroom and laundry facilities generating wastewater from toilets, baths, showers, lavatories, and clothes washing. Well, some of you have sites with maybe everything but a toilet, etc. And the question we're getting several times is, do I have to have a septic tank when there's no toilet there? According to this, well, it can't go in the pit, and you got to handle it according to law otherwise, so yes. And that's, we're talking, septic tanks, they just, I don't need to tell you how much they cost, even though I had to put one in the old farmhouse because it was dumping in the ditch, and it was legal. It was legal. But I had to put leach fields in, and I know what they cost. Okay. So here's what's come up. What if DNR comes out and you don't have that, but it was built before May 12, 1999. Rule wasn't in effect then. You need to tell them that it wasn't required then. And again, that's one of those effective dates you need to know. Water source separation distances, those have changed over the years. You need to know the ones that were in effect when your operation built. This is the one on expansion of that we all know is in the code itself, where you get the distances from the neighbor's house that were in effect at the time you built. Very helpful part of the law, and the one that we don't want you to lose if you repopulate. Okay, I'm on to something else now where we're going to move right through this, but I want to stop. Another one I don't have the slide on, road right-of-way. This just came up a few weeks ago. DNR looked at a MMP, I forget what it was, in a non-construction expansion and said, well, this building's within 100 feet of the road, and that you have to be at least 100 feet from the road right-of-way. You need to get a waiver from the county. Wait a minute. Road right-of-way distance requirement went into effect on January 1, 1999. That building was built before that. Doesn't apply. Responded to DNR, and they responded with, okay, you're okay. My point is, and maybe I'll try real hard to have something put together where we have all these effective dates, because they don't jump out at you, folks. You got to go look back when the legislation was adopted, when the rule was in effect. My point is, for your customers, or if you're the producer, know when you were built, and know if you can give that date to DNR, that'll be a big help to avoid them trying to apply a regulation that's in effect now that wasn't in effect at the time you built. Okay? Animal capacity, we've covered this many times in past years. I put the slides in here. It's this, less than 55 pounds, more than 55 pounds in figuring your animal unit capacity. We have some examples here for double stocking those pigs. Do they all have to be out before 55 pounds? No, it's based on the number. I have it here on slide 61 that how you should calculate that. I know some of you, Chris Cole at Iowa State a few years ago developed a spreadsheet to help you accurately calculate your animal capacity so that you're not in violation. Okay? Here's my slide, confinement operations 1 or 2. That's the common ownership or management. And questions come up every year where you have buildings that are closer than the distance, either, where are we? Next slide, 65, 1250 or 2,500 feet to determine if you're one operation or two. It boils down to, and here it is, slide 67. Is there common ownership? You look at a 10% ownership interest in any entity. If you don't have that between these two operations that are across the road or whatever, may have father, daughter, son scenarios, etc. Then the rule definition, I'll move to common management. This is the one that catches most people. Even if you have separate ownership, daughter owns this building, mom and dad own this building, okay? Cross road from each other, but they're separately owned, okay? The goal is to keep them separate. Then maybe you don't need an MMP, don't need a construction permit, etc. DNR has a list of factors they look at, and you've seen this slide before, slide 70 on whatever it is. I included it again because I was talking about this, but here's what DNR has done. The last time, just 6 months ago, I worked on something like this. When they sent me the questions, they have the word specifically in there where it says who has control. It now says who specifically has control. I guess I wasn't being specific enough before, but anyway, these are questions DNR will ask to determine if there's common management, okay? And you provide those answers back to them, and I'm told by DNR that they have, most of the time when they get these answers back, they determine there is not common management. So I lay them out here on these slides. Some people tell me, there was a proposal a few years ago that if you had the same electrical meter or something like that, that's not in there. Now, it's probably not a good idea to have the same electrical meter because it asks who pays the utilities, but These are the specific questions that DNR asks to determine if there's common management. So, and I'm not up here to tell you to do this or don't do this as far as, splitting the sites. I'm just telling you what the law says. If you are going to do it, pay close attention to the law and pay close attention to these factors. Go through those factors ahead of time to make sure you're okay. All right? Environmental self-audits. This is probably what we're going to end up with. 5 minutes. Before, I've always included this slide. If you discover that you have a violation in your operation or one of your clients does, and DNR has not discovered that, you just determined that something that darn McAfee said that I'm in violation, and you confirm it's a violation. To avoid a penalty, okay, here's what you need to do. You file 2 pieces of paper with DNR. Slide 73, you file a notice of self-audit. And this law applies not just to livestock, if anybody gets critical of us here. This law was adopted in the late 90s for all businesses that deal with environmental regulation. It's intended to be, okay, you found out you have a violation, don't feel you have to hide, hoping DNR never finds you. Submit it, do what we have to do in these notices, and then you'll be in compliance, and you won't be hiding, okay? And DNR has been very, very supportive of this self-audit process. First of all, you file a notice of self-audit, then you file, and I often do them the same day, but the rules require 2 different notices, and I lay out here in these 2 slides exactly what the rules say you need. Many of you do these or work with somebody who does these. I find them very helpful to help get clients into compliance when they didn't realize they were out of compliance, okay? Where's my... I got to look. Nope, this is the slide I wanted. Sorry to go back and forth. Here's one thing that DNR has done, depending on the field office. Once you file these, of course, one of the things you have to tell them is what you're going to do to fix it. You can't just say, I found it, haha. You have to say, I will correct it, and here's how I'm going to correct it, and here's when I'm going to correct it. Now, technically, that's a violation. You discovered it. DNR didn't, but it's still a violation. Some of the DNR field offices are going ahead and issuing an NOV, a notice of violation. And yeah, a couple of you are frowning at me. Some don't, some do. And I don't like it because I think it gives the wrong impression. But if you're in a field office that does that, and I don't... First of all, get it filed before you talk to the field office, okay? Don't talk to them first and then file it. You need to do this before DNR is aware of a violation. You file it, the field office gets it, then if they contact you or you contact them, and if they are going to issue an NOV, I think I would say, I really don't like that idea because, hey, I did this. I self-reported it. I don't want it to appear that I was hiding and didn't do anything until you found it. If they are going to issue an NOV, I think the NOV should clearly state that the violation was discovered and self-reported by environmental self-audit. And I've talked to the state office, and they have said they will talk to field offices about if they are going to issue an NOV to include that type of language in it. Okay? Harrison, I have a minute yet. Gosh. Slide 76, 77, forget about Federal Clean Air Act compliance. Just hold on. We should be okay. How's that, Randy? I knew you were here for that. Wait a minute. All right. I'm still 1029. All right. I know it was a long haul, but yeah, I should have went a little faster up front and not. But we covered everything that I spent the time on the issues I think were important. And I hope it's helpful. If you have any questions, please feel free to get a hold of Harrison. Harrison's new, but we'll get him indoctrinated here. He'll be up to speed in no time. And thank you for coming, and enjoy Pork Congress.